Hello friends, welcome to my YouTube channel, MT Zaman's Polity and Governance. I am MT Zaman, your educator and mentor. Friends, this is going to be my first video on YouTube. Thanks to the persistent demand from the student community that I must come up with some videos, educational videos on YouTube, on the virtual world. Right? So finally, I decided to come up. Initially, I was reluctant because of the regularity and consistency that it demands. Right? So because of my busy schedule and that too erratic schedule, that I was not very sure whether I would be able to continue with the regularity and consistency that people would expect me to do. So finally, I'm there. It's never too late, they say. So guys, definitely, I would require your support and cooperation to keep myself going. So all you have to do is to like, subscribe, and share the videos if you find the videos useful. I also believe that sharing is caring. Probably love and knowledge. These are the two things that keep compounding, that keep growing when you share. So friends, get started. Today I'm going to discuss this Prelims 2024 questions, GS-Polity and Governance. You know, on 16th June last, UPSC conducted its prelims examination for the latest batch. I'm sure many of you might have appeared in this examination and you must have also got hold of the answer keys. You must have evaluated your performance. And many of you may not have appeared this time. You are planning to appear next time. Okay, so this video is going to be very useful for you because I am not only going to discuss the answers, but also the various nuances involved in solving the questions. And that will also give you insights into the pattern of asking questions that is followed by the UPSC. Although there is no set pattern, but still you can get some broad idea as to what kind of questions are asked, from where they choose, what are the catchment areas in your polity and governance sections of GS paper 2 main examination, right? So the first question, GS paper 1, that is paper 1, set A. There are set A, B, C, D. So I have chosen set A. Now the first question is question number 61. Who was the provisional president of the Constituent Assembly before Dr. Rajendra Prasad took over? Now, if you go through the Constitution and about the Constitution, how the Constitution was framed, you know that Constituent Assembly was set up. And then the Constituent Assembly started functioning on 9th December 1946. 9th December 1946. That was the first ever sitting of the Constituent Assembly, which eventually framed the Constitution of India. So on that day, Dr. Sachidanand Sinha was appointed by the Governor General as the provisional president of the Constituent Assembly. He administered oath of office to the newly elected as well as nominated members into the Constituent Assembly. And then on 11th, 2 days after, on 11th December 1946, 11th December 1946, Dr. Rajendra Prasad was elected by the members from amongst themselves to be the President of the Constituent Assembly. So, since the question is asking you about the provisional president, so it must be Dr. Sachidanand Sinha, who was appointed, who was not elected, but appointed. And Dr. Rajendra Prasad became the President of the Constituent Assembly, and he was elected on 11th December 1946. So remember these dates, these are important dates. So when you study the Constitution, about how the Constitution came into existence, the functioning of the Constituent Assembly, etc., you get these important facts. Okay, so this should be the answer. Now the next question is, with reference to the Government of India Act 1935, consider the following statements. Now, there are two statements given. The first statement says, it provided for the establishment of an all India federation, right, based on the union of British Indian provinces and princely states. Now, you know, at that time, there used to be three types of territories in India. One, directly governed by the British, those were referred to as British provinces, British Indian provinces. Another category, princely states, okay, smaller princely states, more than 550 princely states were there, right? And then there was another category, smaller category, comprising few territories, and those were chief commissioners' provinces, right? So here, the question says, the statement says that the Government of India Act 1935 that provided for a federation, a federal system, comprising the two types of categories. One is British Indian provinces and another is princely states. So if you have read the history of constitutional development, various acts that were passed by the British Parliament, and that also reflects the evolution of the political system in the country. So you would know that Government of India Act 1935 was a very important, landmark legislation passed by the British Parliament. And one of the most important features of this act was the provision for a federation. So this statement is true. However, you should know that princely states were given a choice. If they wanted to join the federation, okay. If they did not, that would also be okay. So they were given a choice. Okay. So to which the Indian nationals, they had disagreed. They showed their opposition to this kind of provision, that they should not be given, they should be compulsorily made to join the federation. Anyways, the statement is true, right? That the federation would comprise British provinces as well as the princely states. Okay. The next statement is, defense and foreign affairs were kept under the control of the federal legislature. Now, this is factually wrong. Defense and foreign affairs, okay, partly correct. They were kept under the control of the Governor General, right? Not with the federal government or state government. It was, these two subjects, defense and foreign affairs, were kept with the Governor General of India, right? So this is wrong statement. So which will be the answer, correct answer? The answer should be this one, okay? So next question. As per Article 368 of the Constitution of India, the Parliament may amend any provision of the Constitution of India by way of addition, variation, repeal. So this is a question directly from the articles, provisions of the Constitution, right? Now, if you go through Article 368 properly, then you would know that any kind of addition, any kind of variation, that is alteration, repeal, or we sometimes also call deletion. So any kind of deletion, alteration, or you can say repeal or variation, and addition, and even substitution. And this will come here itself. Variation means variation will include alterations as well as substitution. So if a word is replaced by another word, if a clause in the Constitution is replaced by another clause, if a part is replaced by another part, so this is called variation or substitution or alteration, right? So all these three are correct, right? So answer should be D. Fine. Now, which of the following statements are correct in respect of money bill in the Parliament? So it talks about money bill, and this is again directly from the constitutional provisions, right? And these are very important things, money bill, finance bill, all these are very important things. Now, Article 109 mentions a special procedure in respect of money bill. So this is clearly correct. Okay. Article 110 tells about the procedures. right? Sorry, 109 tells about the procedure, 110 talks about the definition of money bill. Fine. So this is correct. A money bill shall not be introduced in the Council of States. This is also correct. Money bill and financial bills, these are introduced only in the Lok Sabha. Later on, once the Lok Sabha completes its business there, then only it is referred to the second house, that is the Rajya Sabha. So, this is also correct. And third statement, the Rajya Sabha can either approve the bill or suggest changes but cannot reject it. Yes. When a money bill goes to the Rajya Sabha has only fewer options. Rajya Sabha has the option of either approving it, then fine. Rajya Sabha may reject it, but still it will be considered passed. Rajya Sabha cannot amend, it cannot introduce any kind of amendment into the provisions of the money bill. It can only suggest certain amendments. So there is a difference between suggesting amendments and making amendments. Okay? So Rajya Sabha can only suggest amendments, it cannot make any amendments. But then when it suggests amendments, then the bill will also once again go back to the Lok Sabha. If the Lok Sabha agrees with the amendments, okay. If it does not agree with the amendments suggested by the Rajya Sabha, then it will declare the bill passed in its original form, the form in which Lok Sabha had passed the bill onto the Rajya Sabha. Fine. So Rajya Sabha has no effective powers to amend a money bill. Right? So this is correct. It cannot reject. Fine. It can approve. It can approve. It can suggest changes, but it cannot reject. Amendments to a money bill suggested by the Rajya Sabha have to be accepted by the Lok Sabha. No, it is not compulsory, as I already discussed. So this is a wrong statement. So which will be correct answer? Correct answer would be C, 1, 2, and 3. Okay, next question. The North-Eastern Council was established by the North-Eastern Council Act 1971. Fine. This statement is correct. Okay. Subsequent to the amendment of NEC, that is North-Eastern Council Act, in 2002, the council comprises which of the following members? So that's the question. The question is about the composition of the North-Eastern Council. And this is from governance, the field of governance. There are many institutions in our country which are important institutions. Some are constitutional bodies, others are statutory bodies, and yet others are non-statutory, non-constitutional bodies, and yet some of those are very important. For instance, you have Niti Aayog. Niti Aayog is neither a constitutional body nor a statutory body, and yet it is a very important institution. So, as a student, as a civil services aspirant, you have to keep a close watch over the functioning of the governance system, whichever institutions are important, and how would you know whether a particular institution is important? On the basis of newspaper reports, you can make out which one is important and which one is not that important, right? So North-Eastern Council, this is a council that was created by an Act of Parliament in 1971. So it is a statutory body. However, in 2002, the law was amended, the act was amended to, provide for a new kind of composition. And according to the amended law, what is the composition of this council? So, governor of the constituent states. So now, if you go through the North-Eastern Council, you would know that this council comprises 8 states. So 8 states are member states. So 7 sisters, Northeastern, 7 sisters plus Sikkim. So it becomes 8. So all those 8 member states are members of this council. So governor of the constituent states, so 8 governors each from the states, and chief ministers of the constituent state, that's also correct. This is also correct. This is also correct. And 3 members to be nominated by the President of India. Yes, that's also correct. It could be any 3 ministers, cabinet ministers who are nominated by the President of India. It could include Home Minister, but not necessarily. So this is not correct. right? And the chairperson is the Home Minister. Usually it is not given, but chairperson is usually the Union Home Minister. Okay, so which will be the correct answer? Correct answer would be this. Okay, so next question. Which of the following statements are correct about the Constitution of India? So now it's about the Constitution of India. So Constitution of India has many parts. How many parts? Altogether 25 parts. Originally, that is in 1950, when the Constitution was brought into enforcement, brought into commencement, there were only 22 parts. 22. In course of time, with the passage of time, since 1950 till date, 4 new parts have been added. But one part was also repealed. So altogether, today we have 25 parts. Now, a civil services aspirant is expected to know about the various parts of the Constitution. There is 25 parts of the Constitution. Some parts are otherwise also very popular by their name, that is part-wise. There is part 3, there is fundamental rights. Part 4, DPSP, Directive Principles of State Policy. Part 9A, Part 9, Part 9 is Panchayati Raj institutions. Part 9A, municipalities. Part 14A, this is about tribunals. So you have to remember the parts. Now the question is exactly about the parts. The first statement says powers of the municipalities are given in Part 9A of the Constitution. Yes, that's correct. That's correct. Emergency provisions are given in Part 18 of the Constitution. That's also correct. Provisions related to the amendment of the Constitution are given in Part 20. Yes, that's also correct. Now, it gives you a valuable lesson that you should know also about the basic facts relating to the Constitution of India. Often people ignore these things, right? So you should know, you have to be very clear about the basic things. Next year, it may be something related to the parts, certain parts which have been, incorporated in the Constitution subsequently. As I said, 4 parts had been added. Okay, so Part 4A, Part 9A, Part 14A, Part 9B, these are the 4 parts which had been added subsequently into the Constitution. So sometimes they could ask you this way also, which part was repealed? You should know Part 7 was repealed. Okay, so answer would be 1, 2, and 3. This would be the right answer. Okay. Next question is, which one of the following statements is correct as per the Constitution of India? Now here, there is a trick. Interstate trade and commerce is a state subject under the state list. So this question is from the area scheme of division of powers, scheme of division of powers. Division of powers between whom? Between the union and the states. Okay? So, union list, state list, concurrent list. So, as per the scheme of division of powers, it says interstate trade and commerce is a subject that belongs to the state list. I'll come back to this. Interstate migration, this is another subject, is a state subject under the state list. Interstate quarantine, that's another subject, is a union subject under the union list. Corporation tax is a state subject, so this is another subject. So it talks about, this question talks about the various subjects. Now, the trick is that interstate matters, interstate trade and commerce or interstate anything, that must come under the union list because it's a matter between 2 or more states. So it cannot be in the state list. A particular state cannot unilaterally make laws on such matters, and therefore such matters must be with the union government union list. So here, now, interstate trade and commerce can never be in the state list. Interstate migration, this also cannot be in the state list. Interstate quarantine is a union subject under the union list. Yes, that is correct. And corporation tax is a state subject. This is a common knowledge that corporation tax comes under the union government, and it does not come in the shareable pool of taxes. Certain tax proceeds are shared by the union government with the states. For instance, income tax. We pay income tax to the government. Which government we pay? It is levied by the central union government. It is collected by the union government. But part of the income tax, proceeds from the income tax, has to be shared by the union government with the states. But corporation tax is such a union tax which is not shareable, which is not, shared by the union government with the states. Okay, so next time you could be asked differently. So these are, even though these questions have been asked, you should know the nuances. Okay, so which option would be correct? So C is the correct answer, right? Next question, under which of the following articles of the Constitution of India has the Supreme Court of India placed the right to privacy? Now, this question is related to current affairs as well as from the area of judiciary, right? And from the area of rights. So in the Constitution of India, we have talked about rights, we have talked about judiciary, legislature, executive, judiciary. So this question is squarely from the judicial sphere. Now, right to privacy judgment was delivered recently in 2018 in the Puttaswamy case, right, by the Supreme Court. And it said that even though right to privacy is a right that inheres through the entire Constitution, particularly through the entire Part 3 of the Constitution that talks about fundamental rights, but more specifically, it is implied under Article 21, that is right to life and personal liberty. Right to life and personal liberty. So it is an right to privacy is an aspect, is an important dimension of right to life with dignity, right? So this is the correct answer. Next question. What are the duties of the Chief Defence Staff as the head of the Department of Ministry of Affairs? CDS. Okay, CDS is a relatively new institution that has been created in our governance system. So this is a question that has been asked from the governance area. And it also is about an institution. As I said earlier, there are many institutions which are very important institutions of governance. So CDS, Chief of Defence Staff, is also one of those important institutions. Now, CDS, as the head of the Department of Military Affairs, so he heads the Department of Military Affairs. Now, as such, it gives you three options, three statements. One, permanent chairman of Chiefs of Staff Committee. Yes, that's correct. He is a permanent chairman of Chiefs of Staff Committee. And this Chiefs of Staff Committee comprises, all the three chiefs. Naval Chief, Army Chief, and Air Force Chief. So this committee is chaired by the CDS. It exercises military command over the three services chiefs. No, this is not correct. Why it is not correct? Because each of the chiefs, respective chiefs, like the Naval Chief, Air Force Chief, and Army Chief, they are independent decision makers in their respective fields. However, for proper coordination among the three staff, among the three chiefs and the three wings of the, our armed forces, this CDS has been created. This institution has been created. So this institution has been created to bring about coordination, proper communication, inter-segment coordination, communication, and for effective supervision, and not to issue command and control. So he does not command, he does not control the other three chiefs. The three chiefs are independent in their own right. Principal military advisor to Defense Minister on all tri-service matters. Yes, that's correct. Because earlier, the Defense Minister used to be advised by each of those three chiefs, in their respective spheres. Naval matters, Naval Chief would advise the Defense Minister. On Air Force related matters, Air Force Chief would advise the and army related matters, army chief would be advising the military, advising the defense minister. However, this created a problem of coordination and no effective communication, and therefore now it would be one point of contact. So CDS, Chief of Defense Staff, would be part of this committee, and as such he would have information relating to all the three wings of the defense forces, and he will be the principal military advisor to the defense minister. Even though the other three chiefs will also be defense advisor, but they will not be the principal. So finally it is the defense principal military advisor, CDS, to the defense minister, right? So this is not correct, this is correct. So statement 1 and 3 are correct with respect to this. So this would be the correct answer, right? Next question. Which of the following statements about ethics committee? Now this is again something relating to current events. It has some connection with the if you remember Mahua Moitra, who was finally expelled, disqualified from her seat in the Lok Sabha. It was on the recommendation of ethics committee that she was disqualified. Okay, so this was in the news, but this is also relating to the internal parliamentary functioning. So in the syllabus you have parliament, that is legislature, judiciary, executive. Parliament is a very catchment area. A lot of questions are asked from the parliamentary procedures, whether it's relating to bills, various types of bills, whether it's relating to the functioning of speaker, whether it is relating to the accountability issue, or whether it's relating to various committees, standing committees, etc. So this is a very broad area, parliamentary functioning and procedures of parliamentary functioning. So this is a question that is from that area in the Polity and Constitution. Now it says that initially it was an ad hoc committee. Yes, if you go through the genesis of the ethics committee, initially in the Lok Sabha it was constituted as an ad hoc committee, not as a permanent committee. Only a member of the Lok Sabha can make a complaint relating to unethical conduct of a member of the Lok Sabha. Yes, no, even we ordinary citizens can make a complaint against any Lok Sabha members, but we have, this complaint has to be routed through a Lok Sabha member. So only a Lok Sabha member can file a complaint against any other Lok Sabha members for against their unethical conduct. Okay, so this is correct. This committee cannot take up any matter which is sub judice. Yes. No complaint could be filed with the ethics committee if such matters are under the jurisdiction of the court, under the purview of the court, sub judice. Okay, so this is also correct. So 1, 2, and 3. This should be the right answer. Now next question is, a writ of prohibition is an order. So now this question is relating to various types of writs. Mandamus, certiorari, prohibition, quo warranto, habeas corpus. These are various types of writs. Now this question is on prohibition, writ of prohibition. A writ of prohibition is an order issued by the Supreme Court or High Courts to, if you have read, mandamus and, prohibition and certiorari. These are the writs which are issued by the higher courts against the subordinate courts or inferior courts. Inferior is a term that is used for subordinate courts, or you can say subordinate courts. Okay, so this is Supreme Court or High Court. 2, a government officer? No. As I said, that prohibition and certiorari, these are the writs which are issued by higher court to lower courts. To the Parliament or Legislative Assembly? No. The lower court? Yes. The lower court prohibiting continuation of proceedings in a case? Yes, that's correct. Okay. So the purpose behind issuance of the writ of prohibition is to forbid, to prevent, okay, a lower court from proceeding further on a given case. Okay, so the higher court may demand that, okay, now you do not proceed, let's give the matter to us, or let's transfer the matter to another court. Okay, so this is what is the purpose of the writ of prohibition. And the next, the government prohibiting it from following the unconstitutional policy. No, it cannot issue, this writ cannot be issued to the government, right? So this is also wrong. So this is the right answer, C. Next question is, consider the following statements. It is the governor of the state who recognizes and declares any community of that state as a scheduled tribe. No, it is the power of the president. Okay, whether it is scheduled tribe or scheduled caste, it is the power of the President of India to notify a particular social group as scheduled tribes or scheduled castes. Okay, Parliament has the power to bring about variation in the notification in the list of scheduled castes or scheduled tribes notified by the executive order, right? So it is not a matter that can be done by the governor at the state level. Okay, so this is not correct. A community declared as a scheduled tribe in a state need not be so in another state. Yes, that's correct. Say a particular social group could be considered, could be recognized as a scheduled tribe in Rajasthan, may not be considered the same in Haryana or Uttar Pradesh, right? So that's correct. So this is not correct, this is correct. So which one is the right answer? The right answer is this. Fine. Now the question is, with reference to the union budget, consider the following statements. Now again, this question is from the field of parliamentary procedures. Parliament has a very important responsibility of, approving the government's demands for grants, that is budget, a statement of expenditure and revenue, that is called budget. So Parliament has the responsibility to approve the government's estimates for grants and also relating to taxation proposals. So this is a very important area in the parliamentary functioning. Now the question is, with reference to the union budget, consider the following statements. So now the first statement, the union finance minister on behalf of the prime minister lays the annual financial statement, that is budget. This is what is called budget, AFS. Annual financial statement is what is called budget in common parlance, before both the houses of parliament. No, this is factually wrong, because it is not the Prime Minister on behalf of the Prime Minister, rather it is on behalf of the President of India. Article 112 clearly mentions that it is the responsibility of the President of India to lay before the House, the annual financial statement. But it is not the President. Practically, it is the Union Finance Minister who represents the President in the Parliament in this matter. So this is not correct. Okay. Second question is, at the union level, no demand for a grant can be made except on the recommendation of the President of India. Yes, this clearly mentioned in the Constitution. No demand for grant can be made, okay, except on the recommendation. Prior approval has to be taken from the President of India. So this is correct. So which will be the right answer? Right answer would be B. Fine. So the next question. With reference to the speaker, now the question is relating to again parliamentary procedures, and that includes the institution of a speaker, the speaker's powers, the speaker's responsibilities, the speaker's special position. There are so many aspects of the topic on speaker. So with reference to the speaker of the Lok Sabha, consider the following statements. While any resolution of the removal of the speaker of the Lok Sabha is under consideration, he or she shall not preside. Yes, that's correct. Okay. So when a resolution for the removal of the speaker is in the process, is underway, the speaker shall not preside over that meeting, right? He will participate in the proceedings of the parliament, proceedings of the house, but he will not chair, he will not preside over, right? He shall not have the right to speak. No, this is not correct. He can speak, he can even vote, right? But he will not chair. He shall not be entitled to vote on the resolution in the first instance. No. Yes, the speaker usually, Speaker is prohibited from exercising his votes on everyday matters. When any resolutions are passed, when a bill is passed, he is expected not to vote. But he will vote only when there is a tie of votes between opposition and the ruling members. If in the House there is an equality of votes on a particular resolution or the passage of a bill or a motion, etc., then only the speaker steps in and he removes the, he unlocks the tie, he breaks the tie by casting his vote. So his vote is called casting vote. But this does not apply in this case when a resolution has been taken up to remove the speaker, right? So this is not correct. Okay, so which one is correct? This one is correct. Okay, so the answer would be this. Next question, with reference to the Indian Parliament, consider the following statements. A bill pending in the Lok Sabha lapses on its dissolution. Yes, this is given in Article 107. What happens when a bill is introduced in the Parliament, right? So it's the Article 107 talks about the passage of bills in Parliament. So a bill pending in the Lok Sabha lapses on its dissolution. Yes, that's correct. When a bill is introduced in the Lok Sabha and before it could be passed, if the Lok Sabha is dissolved, then the bill will lapse. Okay, so that's correct. A bill passed by the Lok Sabha and pending in the Rajya Sabha lapses on the dissolution of the Lok Sabha. Yes, that's also correct. When a bill is introduced in the Lok Sabha has already passed and it has gone to the Rajya Sabha. But in the meantime, Lok Sabha is dissolved, then the bill shall lapse. Why? Common sense. That in case the Rajya Sabha brings about amendments into bills, into that bill, then the bill will come to the Lok Sabha once again. But since the Lok Sabha has been dissolved, then and therefore the bill shall lapse. Okay? So this is also correct. A bill in regard to which the President of India notified his or her intention to summon the houses to a joint sitting lapses on the dissolution of the Lok Sabha. Yes, that's does not lapse. Does not lapse. Yes, that's incorrect. So when a bill has been passed by the Lok Sabha and has been defeated by the Rajya Sabha, or the other way around, I mean the vice versa maybe, so one house agrees and the other house does not pass the bill, so that's a situation of deadlock. Now if in that case the President of India has already notified for the summoning of joint sitting to consider the bill, and in the meantime Lok Sabha gets dissolved, then the bill shall not lapse, right? So this statement is incorrect. So the correct statements are 1 and 2. So this is the right answer. Next question is, with reference to the Parliament of India, consider the following statements. Prorogation of a house by the President of India does not require the advice of the Council of Ministers. No, it has to be done on the advice of the President of India. Prorogation, summoning of the house, okay, dissolution of the house, all these things are done by the President of India. I mean, he has the power, but he has to exercise that power on the recommendation of the government, that is Council of Ministers. So this is not correct. Prorogation of a house is generally done. So this generally is very important. Generally done after the house is adjourned sine die. But there is no bar to the President of India prorogating the house which is in session. Yes, generally what happens when the session is on, finally the session is adjourned sine die, means without giving any time for resumption of the session by the speaker, then this is called adjournment sine die, suspending the house without mentioning a date for resumption of the session, right? So that is called adjournment sine die. But once the house is adjourned sine die, then the President of India does the next step, that is dissolution of the house. But this dissolution of the house has to be done on the recommendation of the Council of Ministers. So generally done after the house is adjourned sine die, but there is no bar to the President of India prorogating the house which is in session. Yes, that's correct. There's no bar. He can, prorogue, that is, he can bring down the session to an end, right? Correct. Dissolution of the Lok Sabha is done by the President of India, who, save in exceptional circumstances, does so on the advice of the Council of Ministers. Yes, that's also correct. That in exceptional circumstances only, he may dissolve the House without the advice of the Council of Ministers. Okay, but usually he must dissolve the House only on the recommendation of the Council of Ministers. Maybe sometime it may so happen that the House is going to complete its term of 5 years, but the outgoing government has not recommended the President of India to dissolve the Lok Sabha, right? So it is the responsibility of the President of India to not remain a mute spectator to such a situation. He may dissolve the House on his own initiative. So those are exceptional cases, not regular cases. Otherwise, on routine basis, the President of India dissolves Lok Sabha only on the recommendation of the Council of Ministers. Okay, so 2 and 3 are correct. These are the right answers. Okay, so now guys, this is the list of answers. You can take note of it. You can match your answers, right? Now, if you go through the syllabus, if you give a look at the syllabus, some questions have been asked from historical underpinnings, as it's mentioned in your GS paper 2 in the main examination. GS paper 2, in which you have polity and governance apart from IR and social justice. So in the syllabus, you have the topic historical underpinnings. So question number 61 and 62, you can match the same, this from this. Constitutional provisions directly from the Constitution, from the Constitution provisions, 74, 84. For instance, which part, okay, which article, this kind of questions have been asked. Parliamentary procedures, which is also part of Constitutional provisions. So these are the questions which have been asked. So a long list of questions have been asked from the sphere of Parliament, from the field of Parliament, Parliament's institutions, whether it's speaker or relating to bill or any such matters. So it's parliamentary procedures. Judiciary, one question has been asked, right to privacy wala, that's judiciary. A scheme of division of powers, that is federation, federal system, this has been asked, that interstate trade and commerce, etc. Okay, and current related topics like ethics committee or such questions relating to that, these have been asked. And governance, these questions have been asked. Okay, like institutions like Northeastern Council, okay, and such other institutions. Okay, so you see, questions are asked from every aspect of the syllabus, every topic that has been mentioned in the Constitution in your syllabus. But then this is the largest catchment area from where you can get the maximum number of questions. It happens almost every year that, so Subhash Chandra Kashyap, he has written a book, Our Parliament, NBT publications. You should go through that book. Okay? So thank you guys and best of luck. Those who appeared this time and those who have not appeared, even for them, all the very best. You must understand the nuances, okay, of questions that are asked in the examination. While preparing for the polity and governance section, or for that matter, any other section, you should also, at the same time, keep referring to the questions which have been asked in previous years. That will give you valuable insights.